Hello again, everyone, and welcome to Miscarriage of Justice. Let's get right into it with the completion of last week's lecture. Now, last week we left off talking about constitutional provisions supporting innocence protection. And we talked a bit about the Fourth Amendment and the Fifth Amendment and left off at the Sixth. So the Sixth Amendment guarantees several trial rights, right? So the right to counsel, right to confront witnesses, right to a speedy and public trial, and a right to impartial jury. What do each of these mean? The right to counsel, it's ensuring defendants have legal representation to present their interests. So the key case for this was Gideon v. Wainwright in 1963, and it established the right to counsel for indigent defendants or defendants that don't have the ability to get their own counsel. And the next one is right to confront witnesses. So this allows for cross-examination, and it's particularly crucial for exposing false testimony and revealing exculpatory evidence and so on and so forth. The right to speedy and public trial. This reduces the risk of evidence degradation and it allows public scrutiny of proceedings. And finally, the right to an impartial jury. This aims to ensure a fair evaluation of evidence. Now, the next amendment that we want to talk about is the Eighth Amendment. So the Eighth Amendment prohibits cruel and unusual punishment. It's particularly relevant to the issue of innocence because the proportionality principle within the Eighth Amendment is suggests that punishing an innocent person is inherently disproportionate, right? It's inherently violating the Eighth Amendment. So in capital cases specifically, it provides additional safeguards due to we can't take it back, right? You cannot take back capital punishment. The key case in this instance was Herrera v. Collins in 1993, and while it didn't establish a freestanding innocence claims, it did suggest that executing an innocent person would be absolutely unconstitutional. Now, the 14th Amendment is where we see the due process clause. And we've kind of talked about the due process clause a little bit over the course of the last few weeks. And within the due process clause, we apply the Bill of Rights protections to state actions, right? And we ensure fundamental fairness in criminal proceedings. This is specifically relevant to innocence because it requires states to provide adequate post-conviction, procedures, and it's the basis for challenging convictions based on new evidence of innocence. The key case in this instance is the District Attorney's Office v. Osborne, which is 2009. And again, while it didn't outright establish a constitutional right to post-conviction DNA testing, it left open the possibility in certain circumstances for that to be the case. Now, these protections, they work together and they create a comprehensive framework for protecting the innocent. For example, the right to counsel, the Sixth Amendment right to counsel, helps ensure that the Fourth and Fifth Amendment rights are properly asserted. You see what I mean? Like, we have to think about these rights working together in conjunction. And there has been an evolving understanding of these protections. The Supreme Court's understanding of these protections has evolved over time. And recent decisions have sometimes narrowed these protections, which we talked about a bit last week. And that really highlights like this ongoing need for vigilance. Now, these constitutional provisions, they are the bedrock of innocence protection in our legal system. They reflect this fundamental commitment to protecting the innocent from wrongful conviction. But as we've kind of seen over the last few weeks, there are obstacles to justice, right? Practical application of these principles, it often falls short, right? And understanding these constitutional foundations is, as we've kind of said again and again, one of the most crucial steps for us to begin to bridge the gap between our ideals and the reality of the criminal legal system. And now that we've kind of explored the constitutional basis for innocence protection altogether, I do want us to revisit particularly the Anti-Terrorism and Effective Death Penalty Act, so the AEDPA, and how it's impacted innocence claims. And, you know, habeas corpus altogether was dramatically altered by this act. The AEDPA, I do have difficulty saying that, it largely restricted federal courts' ability to review state convictions, and it also introduced this concept of evidence as a whole standard, which has become a crucial tool in innocence cases. Now, to explore this in some detail, the original purpose of federal habeas corpus, it dates back to the Judiciary Act of 1789. It was intended as a safeguard against unlawful detention. It expanded significantly during the civil rights era of the 1960s, and it serves ultimately, or it served past tense, right, as a constitutional check on state courts, ensuring protection of federal rights. Now, pre the ADPA, federal courts had broad authority to review state convictions, and they could often consider new evidence not presented in state courts. And then the federal courts were less deferential to state court decisions. A key case here, if this is something that interests you, is Brown v. Allen in 1953. They established the de novo review of federal constitutional claims. But the AADPA Act was passed in 1996 in response to some concerns about delays in capital cases and the perceived abuses of habeas corpus. And this significantly restricted federal courts' ability to grant habeas relief, and it imposed strict time limits and procedural requirements and a greater deference to state court decisions than we'd seen before. This concept of evidence as a whole standard, right? It was added, the statutory basis of it was added by the AEDPA in 1996, and it derived from pre-AEDPA Supreme Court decisions, specifically Sawyer v. Whitley in 1992, which established an actual innocence gateway for otherwise barred claims. The scope of this standard, right, it allows for consideration of all evidence related to the claim. So evidence from the original trial and appeal, evidence presented in state post-conviction proceedings, new evidence presented in federal habeas petitions. So it wasn't limited by the rules of admissibility that would apply at trial. And when we're talking about evidence as a whole, the application in successive petitions was particularly important, right? So it allows courts to consider cumulative evidence across multiple proceedings, and it provided a path for review even when individual pieces of evidence might be insufficient. Now, interacting with this new act with the DPA, it generally restricts review, right? So the evidence as a whole standard can broaden the scope of what courts can or can't consider. And this creates a tension between the ADPA's goal of finality that we discussed last week and the need for thorough review in potential innocence cases. Now, this evidence as a whole standard, it represents a crucial opening within the ADPA's otherwise incredibly restrictive framework, and it allows federal courts to take a more comprehensive view of potential innocence claims and consider the totality of evidence across various proceedings. And it's not the end all be all, right? It's not it the evidence as a whole standard will not, necessarily answer all the challenges posed by the ADPA. This standard, evidence as a whole, has proven to be a valuable tool in some cases for addressing potential miscarriages of justice. And now that we've kind of touched on that, and I don't if you feel like confused by that, I'm happy to revisit it, but I wouldn't necessarily stress too much about it, right? Just kind of have a vague understanding of what the ADPA is and the evidence as a whole standard. I do want us to turn our attention a bit to some recent Supreme Court decisions that have significantly impacted the landscape of federal habeas review, particularly in cases involving claims of innocence. So the recent years have seen significant changes, and when we finish this tail end of this lecture, we're going to talk about that some more. But it's particularly shifted in regards to innocence claims. So one of the most impactful recent cases was Shin v. Ramirez in 2022. So a little bit of background on this case. They consolidated two cases from Arizona. So Ramirez v. Ryan and Jones v. Shin. Both cases involved claims of ineffective assistance of trial counsel. And lower courts had allowed the introduction of new evidence in federal habeas proceedings. So some of the key facts: David Ramirez was convicted of murder and sentenced to death. He claimed the defense's claim was that trial counsel failed to present mitigating evidence of intellectual disability, whereas Barry Jones was convicted of murder and sentenced to death as well, and claimed trial counsel failed to investigate and present evidence supporting his innocence. So the legal question here becomes whether federal courts can consider new evidence to support claims of ineffective assistance of counsel when state post-conviction counsel also provided ineffective assistance. So the majority position here was federal courts in post-conviction proceedings cannot consider new evidence to support ineffective assistance of counsel claims if not presented in state courts. And they decided that this applies even in the failure to present evidence, even if it was due to ineffective post-conviction counsel. They emphasized the rationale here was to emphasize the importance of respecting state court procedures. And they argued that allowing new evidence in this instance would undermine the AADPA's goal of finality and federalism. And this interpretation basically barred new evidence, regardless of reason for failure to develop this record in state court. And this has some pretty severe implications, right? Because it severely limits the ability to present new evidence in federal habeas proceedings. And it creates a catch-22 for defendants with ineffective trial and post-conviction counsel. And it effectively closes federal courthouse doors to evidence of ineffective assistance not presented in state courts. And it leaves many with basically no court to hear their innocence claims. It particularly impacts defendants in states with inadequate systems for appointing post-conviction counsel. So we've seen the impact of this kind of reverberate across various places. So number one, it vastly narrows Martinez v. Ryan 2012. So that case had allowed federal courts to hear ineffective assistance claims not raised in state courts due to ineffective post-conviction counsel. Shen significantly limits the practical effects of Martinez by preventing the introduction of new evidence altogether, right? And two, it creates barriers to innocence claims. So we've already kind of discussed the number of innocence claims that have come over the years and the number of innocence claims that have gone unanswered, right? And many innocence claims rely on evidence that wasn't presented at trial due to ineffective counsel. Shen makes it much harder to present this evidence in federal court. Now, this increased importance of state post-conviction proceedings, it places greater pressure on state courts and post-conviction counsel, and it highlights need for adequate funding and training for post-conviction counsel. And it opens up the possibility for, or the potential for, wrongful executions, right? So when we're talking about these cases, again, I want to remind us that there's a very real human cost to these interpretations. So in capital cases specifically, it limits the ability to present new exculpatory evidence in federal court, and it increases the risk of executing innocent individuals, which also has broader implications for habeas corpus. So it continues this trend of restricting federal habeas review, and it shifts the balance that we're discussing further towards finality at the expense of accuracy. Now, Justice Sotomayor's dissent on this was particularly enlightening, I think. She criticized the majority decision's emphasis on finality over constitutional protections and argued that this decision, quote unquote, it reduces to rubble many habeas petitioners' Sixth Amendment rights, end quote. And her dissent highlighted the potential for miscarriages of justice, especially in capital cases. And she further argued that there are many constitutional concerns here, right? So she argued that the majority's interpretation undermines the right to effective counsel, assistance of counsel, and it warned of increased risk of executing particularly innocent individuals, right? So the practical implications here, that she also noted that this decision leaves defendants with no recourse when both trial and post-conviction counsel are ineffective. right? So it emphasized this disproportionate impact on indigent defendants who are highly likely to be people of minority backgrounds. And placing it in that historical context, this decision placed in a broader context, it is showing this increasing trend of restricting habeas review. And it argued that the majority, her dissent argued that the majority's approach contradicts historical purposes of habeas corpus. She left off with her dissent with a call for legislative action, basically suggesting that Congress might need to intervene to protect the rights of habeas petitioners. Now, Shin v. Ramirez, it really represents a significant shift in federal habeas jurisprudence, right? It further restricts the ability of potential innocent individuals to present new evidence. This decision highlights this tension between finality and accuracy in our criminal legal system. And it shows us that there is an incredible, critical need for effective representation at all stages of criminal proceedings. And that kind of wraps up last week's lecture. I didn't want to kind of continue on last week because it was already going for so long, but it ties right into what we want to talk about today, and that's specifically leniency in the criminal legal system and kind of this punitive turn that we've been seeing in the criminal legal space, right? So like kind of setting the stage, right? Over the last few decades, as we've seen from like the end tail of last week's lecture, the United States has kind of undergone a significant shift in its approach to criminal justice. So criminologists have referred to this as the quote unquote punitive turn. Now, what does it mean exactly? And why is it important for understanding race and gender and justice in the United States? So this punitive turn is characterized by several key features: harsher sentencing policies, tough on crime rhetoric, emphasis on retribution over rehabilitation. And I'm pulling all of the lecture material for today from Aya Gerber's, I believe, law review on this concept of leniency in the criminal justice system. So talking about harsher sentencing policies, so consider the rise of mandatory sentences, right? Think about some of the examples that we've heard about in the news, or the concept of sentence enhancements. A good example of this is the three strikes law that's implemented in many states, right? And then think about the tough on crime rhetoric, right? Think about the political campaigns that you're seeing. How often do you hear candidates talking about being quote unquote tough on crime? This rhetoric, thinking about the historical context here, it gained prominence in the 1980s and 90s, particularly with the war on drugs. And we've seen lately this emphasis on retribution over rehabilitation. So thinking about the purposes of punishment and what punishment's for, what message does it send when we focus more on punishing people who break the law versus rehabilitating them, right? The reduction of educational and vocational programs in prisons is really reflecting the shift in our priorities. So taking a moment to think about these changes, how might they affect different communities, right? And we'll come back to that later. Now, there are certain factors that are driving this punitive turn, right? That are driving the significant shift in our approach to criminal justice. And the three things that IS mentions in her law review are changing racial demographics, media portrayal of crime, and political campaigns that emphasize law and order. So thinking about the racial makeup of the United States and how it's changed, how might this have influenced perceptions of crime and justice? So some scholars have argued that as minority populations grew, particularly in urban areas, there has been a corresponding increase in fear of crime among particularly white Americans. And then we shift to media portrayals of crime. So again, thinking about crime shows, thinking about news reports you've seen, thinking about how crime is spoken about on TV, on social media, how do they typically portray criminals and how do they typically portray victims, right? So there's, for example, right, the rise of 24-hour news cycles and the if it bleeds, it leads mentality in the 1990s. It really contributed to this heightened fear of crime, even when actual crime rates were declining, right? And then we have politicians that really emphasize and ride these campaigns of law and order. So think about the popular politicians right now. Can you recall any political slogans or campaigns centered around crime? For example, or historical context, really, Richard Nixon's 1968 campaign emphasized really law and order. And it's often cited as a turning point in the politicization of crime in the United States. Now, consider how these factors might interact with one another. For example, like how might media portrayal influence political campaigns, or how might political campaigns influence media portrayal? How might that manifest in social media spaces like Instagram and TikTok and so on? And then we see uneven applications of punitive policies. So a punishment, right? And this is when things tend to get really interesting and deeply problematic. So this punitive approach hasn't been applied uniformly across all types of offenses or offenders. So the key point here is some offenses and some people who offend have been exempt from this harsh treatment, often in ways that reflect real social biases. And when I say social biases in this instance, I mean biases along race and gender, right? So can you, like, some talking points, some questions for us to think about? As we're having this discussion, think about any crimes that might be treated more leniently than others, despite having similar levels of harm. Think about how an offender's race might, or their gender or their social class may influence how the justice system treats them, right? Some examples for us to consider are white collar crime versus street crime, drug offenses in wealthy, affluent communities versus drug offenses in low income neighborhoods. How do we deal with domestic violence cases and intimate partner violence? As we move forward in this discussion, I want us to keep this idea of uneven application in mind. It's a crucial concept for us to begin to understand how this punitive turn in the criminal legal system intersects with issues of race and gender in our society. And now that we've kind of established this context, I want us to kind of dive into how this punitive approach and the exceptions to it can sometimes lead to what we have been calling a miscarriage of justice, particularly in cases involving minority victims. So leniency as a miscarriage of justice. Now, at first glance, we've been talking about this punitive turn and how the criminal legal system's gotten harsher and policies have gotten harsher. And now I want to talk about leniency, right? And this may seem paradoxical, but I want us to consider how it exists and how it manifests, right? Critics argue that when leniency is applied in selectively, like, biased ways based on the victim's race, on his gender, it becomes a form of injustice. And I want us to examine this in two key areas, right? Where it really particularly manifests in domestic violence cases and in murder cases involving minority victims. Now, historically, domestic violence was often treated as a private matter, not as a crime. This perspective began to change due to, like, feminist activism in the late 20th century. Now, why do you think domestic violence was traditionally seen as a private matter? What do you think the consequences of a view like this could have today, right? Now, the shift that we're seeing occurred for three particular reasons, right? So early focus on resources. So this establishment of women's shelters, of hotlines, and providing resources as, like, this necessary first step to begin getting women out of the situations that they're in. And I'm generalizing and saying, women, because women do experience the majority of domestic violence harm, but that's not to say that men don't also experience it. It's just the numbers are a little more murky there for reasons that I think are evident. And the second reason we've seen this shift was because of criminalization. So activists pushed for domestic violence to be treated as a serious crime. there were some challenges that arose when trying to criminalize behavior that was particularly seen as private, right? And we saw a convergence of interests. So feminist activists and conservative tough on crime advocates, they found common ground in this instance. And this is a very unlikely alliance, and it did impact the policy outcomes as we'll see in a sec. So these efforts, they led to some significant changes in how the justice system handles domestic violence. We saw mandatory arrest policies, we saw special domestic violence courts, and we saw restricted plea bargaining. And I want us to think about the pros and cons of these policies, how they might affect victims, how they might affect perpetrators, how they might impact law enforcement. How, like, despite this shift, right, the narrative around domestic violence often focused on the specific image, right? Innocent, vulnerable, non-female victim. That's the victim that we're thinking about. Deliberately controlling, chauvinistic, male perpetrator, right? That's the immediate place that our brain goes to. And this narrative, while it was powerful in driving change, it had limitations, right? So it excluded many types of victims and situations, right? So it excluded same-sex couples, it excluded male victims, and it reinforced a lot of gender stereotypes. And I want us to think about how these limitations can impact those who don't fit the quote unquote typical victim or perpetrator profile. And then on the flip side, we have murder cases that involve minority victims, right? Critics have pointed out two legal doctrines that can lead to leniency in these cases. So the provocation defense and the self-defense laws. So the provocation, pardon me. So this defense allows murder charges to be reduced to manslaughter if the defendant acted in heat of passion. What situations where this defense can be justified and where can it be particularly problematic? So critics have argued that broad interpretations, broad formulations of this defense, they can excuse killings based on sexist or homophobic beliefs, and they can allow jurors to apply discriminatory social norms. So some examples are men killing female partners for infidelity or for attempting to leave, killings in responses to homosexual advances. So think about how social biases in our understandings, our internalized understandings or externalized understandings of how the world works and how that may influence juries to interpret heat of passion. And then we have self-defense laws, right? So self-defense laws, especially broad formulations of self-defense laws like stand your ground, have also been criticized as far as the discussion of leniency in the criminal legal system. So the key issues, they allow self-defense laws allow for use of force based on reasonable fear, right? And they have the capacity or have the potential to excuse killings based on racial stereotypes. So a couple questions for us to consider. What factors might influence what's considered reasonable fear? And how might this differ across racial or cultural lines, right? And there are a couple high-profile self-defense cases for us to consider that particularly highlight how complex this is and the potential biases that manifest in self-defense laws. Now, these cases sparked significant public debate, and I think they can really shed a light on how race can influence perceptions of threat and the application of self-defense laws. So the case I want to discuss particularly is the Bernard Goetz case, the 1984 New York City subway shooting. So in 1984, Bernard, a white man, shot four young Black men on a New York City subway train. He claimed that the young men were trying to rob him. He fired 5 shots, seriously wounding all 4 men, and he later fled the scene but turned himself in afterwards. The legal outcome here, he was acquitted of attempted murder and assault charges, and convicted only of illegal weapons possessions. So, my questions: how might his perception of threat been influenced by racial stereotypes? This case occurred during a period of incredibly high rate crimes in New York City. High rate crimes? High crime rates, sorry. Please consider how might this context have influenced the jury's decision. And my third question, and maybe a controversial question, but I want us to kind of sit with it, is if the races of the individuals were reversed, if, say, a Black man shot four white youth, how might the public have viewed that? How might the legal system have responded if that were the case? So this case, right, however your opinions are in this case, it really shows how this justification or this doctrine of legal fear or reasonable fear, pardon me, in self-defense cases, it can be influenced by racialized and gendered biases. Bernard's acquittal on these major charges, it suggests that the jury found his fear of the young Black man to be reasonable, despite the absence of weapons. And then we have the more recent case of Trayvon Martin. So in 2012, George Zimmerman, a neighborhood watch coordinator, he fatally shot Trayvon Martin, an unarmed 17-year-old Black teenager in Sanford, Florida. So some key details from this case: Zimmerman called the police to report a suspicious person in the neighborhood. He was ordered not to approach, and despite that, Zimmerman confronted Martin, and Zimmerman claimed defense under Florida's stand your ground law. So the legal outcome in this instance, Zimmerman was acquitted of second-degree murder and manslaughter charges. Now, my questions here are, how did Florida's stand your ground law influence this case? And consider the role of racial profiling. Now that we kind of have this foundation of understanding of how race and gender and other biases influence potential for miscarriages of justice, I want us to kind of ask ourselves, why did Zimmerman find Trayvon Martin suspicious? And how might biases and how might racism affect what's considered to be reasonable fear in self-defense cases, right? This case also brought national attention to stand your ground laws and their potential for racially biased application. It really highlighted how these laws had the potential to excuse killings based on racial stereotypes about who was perceived as threatening. Now, both of these cases have claims of self-defense by individuals who initiated the confrontations. How does this complicate the notion of self-defense, right? In both these cases, the defendants were acquitted of major charges. What does this suggest about how self-defense laws are applied when the perceived threat comes from young Black males, right? And how might these cases and their outcomes affect public perception of the justice system, particularly among minority communities? So those are just questions for us to consider and reflect on while we're thinking about this. And I do ask that we not have a knee-jerk response to this, because I know it can be a highly politicized conversation. I do think it's important to consider within the context of our legal system and how laws are applied. And these cases particularly, they demonstrate how self-defense laws, particularly broad formulations like stand your ground, they have the potential to be used to justify violence, right? Based on racial stereotypes, based on homophobic stereotypes, based on fears that are unfounded. They raise critical questions about how reasonable fear is interpreted in a society with deep-seated racial biases. Now, as we kind of consider these critiques, I want us to think about how legal doctrines that seem race neutral on their face can lead to racially disparate outcomes in practice. And this brings us back to this broader discussion of how leniency in the criminal legal system can sometimes result in injustice or minority victims. for minority victims, right? Consider how these cases, just take a moment, consider how these cases might have been perceived differently if the races of the individuals were reversed, and consider how leniency in the criminal justice system isn't always straightforward. And we have evidence, empirical evidence, that it is applied unevenly, and it has reinforced existing social biases and inequalities. And now that we've kind of touched on these issues, and I wish we had, a longer semester with more classes that we can dive deeper into these. I do want us to take a brief look at how some scholars have critiqued these patterns of leniency and what kind of the solutions are. Because I don't want us to have like this discussion where it's like, here's what's wrong, here's what's wrong, here's what's wrong, goodbye. I want us to also consider that there are realities, there are ways we can imagine the world that are different and better. So we've examined specific cases and legal doctrines. I want us to kind of see what scholars have said about this, how they've critiqued these patterns, and how their critiques go beyond individual cases and address kind of the systematic issues and the systemic issues and how our laws are structured and applied. So scholars have raised several important concerns about the patterns of leniency in cases involving minority victims. When the legal system is lenient in cases involving minority victims, it potentially mirrors and perpetuates existing social biases. So again, going back to the domestic violence cases, how does that reflect broader social attitudes about gender? In what ways could lenient treatment of defendants who claim self-defense against minority victims reinforce racial stereotypes? Think about it in a broader context. Can you think of other areas of law where social biases might be reflected in legal outcomes? So just reflecting a little bit. We also see that leniency in these cases can leave vulnerable populations without adequate legal protection. So who are some of these vulnerable groups we've discussed that might be affected by these patterns of leniency? We've already had this discussion over and over again from week one, right? But how might insufficient legal protection affect these groups beyond immediate legal context? Consider the historical examples that we've discussed where lack of legal protection had broader social consequences. Leniency also undermines the equality principle in law. So the patterns of leniency have the potential to contradict the fundamental legal principle that all individuals should be equal before the law. Now, thinking of the proposed solution, we don't want to just critique, as I've said, we also want to discuss possible solutions that scholars have presented. Number one, narrowing the scope of defenses. So this involves restricting how defenses like provocation and self-defense can be applied, particularly in cases that might involve bias. But I want us to consider, you may disagree with this, how might narrowing these defenses help or not help address these issues that we've discussed? Are there potential drawbacks or unintended consequences that might come from this approach? Can you think of specific ways that these defenses can be narrowed? A second sort of solution that is presented by scholars is implementing the reasonable woman standard. So this approach suggests replacing the traditional reasonable person standard with a reasonable woman standard in specific cases, particularly those involving gender-based violence. And I want us again to think, how might this change in standard, change outcomes in domestic violence cases or sexual assault cases? Are there potential benefits? Are there drawbacks to this approach? Could this concept be extended to other groups? What would the implication of a reasonable minority person standard even be? And the third solution that they came up with is mandating consideration of social context in jury instructions. So this solution involves explicitly instructing juries to consider broader social context, including historical context, including current patterns of discrimination when they are making their decisions. And as we consider these proposed solutions, it's important to think critically about their potential effectiveness and any unintended consequences they may have. These critiques and these solutions, they highlight a complex interplay between law and society, and it challenges us to think about how our criminal legal system can better serve all members of society particularly those who have been historically underprotected. And I want us to talk a bit about the complexities and the unintended consequences that we are dealing with as well. Now, there's a flip side to this, right? A flip side to the potential solutions that scholars have offered or their potential proposals, right? Let's kind of discuss them very briefly. So there is tension with defendant rights, right? So in an effort to address leniency in cases with minority victims, we could potentially flip to the other side and conflict with longstanding protections for criminal defendants. So narrowing defenses like provocation or self-defense has potential to impact defendants' rights to a fair trial, right? So consider what are some key defendant rights that we need to protect or we need to buffer when proposing reforms. How do we begin to balance the need to protect vulnerable victims with this assumption or presumption of innocence for defendants, right? So how do we balance victims and the rights of defendants? And then there's this risk of increasing overall punitiveness. So in an effort to begin addressing leniency and addressing some of the gaps that we're seeing in our legal system, attempts to address leniency could inadvertently contribute to the overall punitive trend in the criminal legal system. So think about it. So how might reforms in this instance that are aimed at reducing leniency for some defendants end up leading to harsher treatment for everyone? And how, like, can you think of historical examples where well-intentioned reforms have also led to increased punitiveness? Think about the domestic violence cases and mandatory arrests, right? And how might increasing punitiveness conflict with other criminal justice reforms, such as reducing mass incarceration, right? So in an effort to do something that we're seeing as good, right, may potentially risk increasing harsher punishments. And then we see there's these suggestions leave room for a disproportionate impact on marginalized communities. So paradoxically, reforms aimed at protecting minority victims have the potential to end up disproportionately affecting defendants from those same communities. So given what we know about racial disparities in arrests and prosecutions, how might stricter enforcement impact minority communities? How might reforms interact with existing biases in law enforcement and in the court system? Consider the ways that we can address leniency that don't risk further marginalizing vulnerable people. So, as we've seen throughout this lecture, the intersection of race, gender, and the criminal legal system is incredibly complex, right? We've explored how the punitive turn in criminal justice has led to patterns of leniency in cases involving minority victims, particularly in domestic violence and murder cases. We've examined some of the critiques of these patterns, and we've considered proposed solutions. However, we've also recognized that addressing these issues is not straightforward. It's crucial to address systematic biases, but also be cautious about the unintended consequences of the ways we're addressing it. So reforms aimed at reducing discriminatory leniency have potential to conflict with defendant rights, contribute to overall punitiveness, or even disproportionately impact the very communities that we're aiming to protect. So you guys watching this, you are future criminal justice practitioners and professionals, right? And it is your responsibility to grapple with these complexities. The challenges we've discussed today, they don't have easy solutions, but they are vital to creating a criminal legal system that is truly just and for all of us, right? And some final talking points that I want to leave you guys with is I want you to consider how the conversations we've had over the course of the last 5 weeks, how they have changed or maybe reinforced your understanding of the criminal legal system. I want you to reflect on your role and how you see yourself addressing these issues in your future career as a criminal justice practitioner or a criminal legal practitioner. And I want you to think about what additional areas of research or inquiry do you think are needed to better understand and address these really complex issues, right? And I want us to remember the law is not just like a set of rules. It's a living system. It interacts with and it shapes our society. And as you move forward in your studies and careers, I really encourage you to keep thinking critically about these issues and to always strive for both equity and fairness in what you do. And I would like to thank you for a fantastic 5 weeks. And yeah, you guys have been great. Please keep up with your choose your own adventure assignments and reach out if you have any questions about the final essay. I'm happy to answer. And yeah, that's it from this course. There will be no more lectures after this. Again, please reach out if you have any questions.